Good morning and welcome to the Employer Education Series. It's in sponsorship with Spectrum Health Occupational Health, the law firm of L'Esperance, and the BHS Insurance firm. We are here today to present to you topics in our first round of the Employer Education Series. My name is Kim Slager. I'm a partner here at BHS, and on behalf of all of our associates, we want to welcome you. Each month, we're going to be presenting a topic to you on the third Thursday at 8:30. This month, we did it a little early just because of the timeliness of the topic, but next month it will be held on January 21st, and we'll be discussing reasonable suspicion. We are looking for additional topics. We have the first quarter of the year already outlined, but after today, we're going to send an email out to all the attendees asking for your feedback and any additional topics you'd like us to address. At the end of this presentation, we will have a question and answer, and so we will take those, and please post those in the Q&A feature. At the conclusion of the webinar, we will also be sending you a copy of the recording from this today, and it'll be distributed to all attendees. So please feel free to share that with your colleagues as well. So this morning, I have the pleasure of introducing to you Mr. Andrew Cassini. He is an attorney and partner at the law firm of L'Esperance here in Grand Rapids, Michigan. He focuses on employment law and has spoken to our audiences before and does a fantastic job. So I think today you'll really appreciate the content that he's bringing timely to the challenges and everyday changes that we have related to COVID, and you as employers trying to manage that with keeping your employees safe and getting the work output that needs to be done as well. So without further ado, I'm going to pass the baton to Mr. Cassini and allow him to speak on the hot topic of COVID and the holidays.
Thank you so much, Kim. I really appreciate the introduction, and I very much appreciate all of you today inviting me through your tablet, through your laptop, through your cell phone, into your home, into your car, into your office, wherever you may be. I guess I want to start with a question. And this question to all of you is, do you guys like roller coasters? Because I'm going to tell you what, I do not. I do not like roller coasters at all. I think they're terrifying. I think they're scary. I pretend to like them around other people because I want to be seen as exciting and spontaneous, but I don't enjoy them at all. I'd like to tell you a story about my two least favorite roller coasters today. My second least favorite roller coaster is the Coney Island Cyclone. The Coney Island Cyclone, you may or may not know, it's located in New York. I went to law school in New York, so I spent 3 years there. It's down in the very, very bottom of Brooklyn. It is a giant wooden roller coaster, which makes it all the more terrifying because you hear it creaking as you go through each of the turns. And if that wasn't enough to make it really, really unsafe, it's also ancient. It's been there since the 1920s or something. I didn't look that up on Wikipedia, but I nearly guarantee that it's true. And it is notorious for having been one of the first really reckless roller coasters. In fact, if you use Google autocomplete, you can see that the very first entry, if you type in Coney Island Cyclone, is Coney Island Cyclone deaths. At the very bottom, you see Coney Island Cyclone accidents, Coney Island Cyclone injuries. Does not inspire confidence. And indeed, if you've ever been on this thing, it's shaking back and forth, the turns, they come rapidly, and you go through a series of emotions when you ride this thing. Most of mine are negative. But my first least favorite roller coaster, which is to say my very least favorite roller coaster, is this roller coaster. The roller coaster that we all just went through, a list of a number of the cases as they have exploded in the state of Michigan during the entirety of the COVID-19 pandemic. And like any roller coaster, it goes through various twists and turns. Like, for example, the first step in our odyssey, it was right here. I like to call this turn back in late March, early April, as a period of blissful ignorance. We kind of moved on around early April to horrified panic. I don't think that I slept in April or May because I had so many clients asking me for advice about what to do. It was the first time in my career that everybody needed an employment attorney, which is a good thing. We went to turn 3, this period of begrudging acceptance around May. We realized this was going to be the way that we were going to have to figure out to work. We got into patterns. We started to hammer out policies. We knew more or less what we were doing. Turn 4, it started to bottom out and get a little bit slower. And we had a moment where we were resuming our confidence in mid-June. I think there was some realistic hope that maybe this would all be over by the 4th of July. And of course, that led to the natural next consequence, which is in turn 5, we got into callous disregard. This is the point in the roller coaster where you think, the ride's almost over. We don't really have to worry about this anymore. However, turn 6 occurred in early October. I like to call this escalating dread. We're worried now at this point. We don't really know what's going to happen, but we see that cases are on the rise, and we're wondering maybe if we need to start taking this serious again. But the most profound emotion that I felt on this particular roller coaster came on turn 7. I've called this turn the crushing depression turn, and that's the one that happened around mid-November as we were about to go into Thanksgiving. Cases were peaking. They showed no signs of slowing down, and we knew we were going through the second wave. It was unequivocal at that point. What I'd like to suggest to you, at least, is that this is a decent lesson about where we are. I think there are some takeaways we can get from the shape of this curve and our journey that we've all gone on together on this roller coaster. The first is, we're going in again, guys. Your HR professionals, your CFOs, CEOs, maybe you're the single manager at your small business, you're going to have to address this topic again. There's just no way around it. And the second takeaway, although there are healthcare providers and essential workers, and we refer to those guys as the boots on the ground, they are the heroes of this story. The HR teams at our organizations, or whoever we have wearing the hat of HR, they play an equally crucial leadership role as we get through this pandemic. It's going to be up to you guys, and I will assist you in getting through the pandemic with our workforces and our businesses intact. We also knew that we learned lessons during the first wave of this thing, and we need to kind of understand what lessons do we need to take into the second wave, and what lessons do we need to throw out because they're no longer applicable. We'll talk about both of those today. We also need to be ready for more and more employees to be out of the workplace as the case numbers explode. And we also need to figure out what challenges our employees will face. We need to be able to step in their shoes and try to figure out what matters to them as the pandemic increases. We need to have a plan to respond to what matters to them. And I think that we also need to be ready because Lord knows, as we've gone through this process, we have gotten an absolute flurry of new laws, new regulations, new executive orders. It's been a whiplash. We need to be ready to respond to that. The number one takeaway that I want all of you to firmly grasp as we're about to go into this presentation is we're right here on the roller coaster. Stuff is about to get exciting. We have a moment to gather ourselves into plan. My name is Andrew Cassini. As Kim told you at the very beginning, I'm a labor and employment attorney at Henn Lesperance. I'm one of the 3 partners there. I chair the labor and employment group. We mostly focus on small and medium employers. We're very proud, however, to be presenting this presentation with the participation of Spectrum Health and Mdhs Insurance today. And we call this COVID-19 and the holidays. Why? Because we're about to ramp up into the holiday season, which means we've got a lot of decisions to make before the holiday happens. And we need to know what the current issues that workforces are facing because of COVID-19 and how to respond to those issues. So this is what I propose that we do today. We've got an ambitious roadmap. First, we're going to talk about executive disorder. In the state of Michigan, we recently had a Supreme Court case that got rid of all of the governor's executive orders. What filled the gap? There's a lot of confusion about this point. I want to set that straight. We're also going to have an update about the Ffcra. We're going to keep the Ffcra 101 stuff out of it because there are plenty of places where you can go and learn about that. I want to talk about the new issues that are arising as we're coming in to the end of December, beginning of January. We're going to talk about the challenges that remote work has caused to your workforce. We're going to talk about some of the solutions that we can maybe go through to alleviate those concerns. We are going to talk about the impact of vaccines, and we may also talk about how horrible I am at titling sections and using puns. Just the vax, ma'am. That's what I came up with last night, so that's what we're rolling with. Then we're going to have a tips and tricks section because I'm getting 5 questions more than anything else. We're going to address those. And then finally, we're going to end with some quick hitters about PPP forgiveness, because I'm just seeing a lot of material, especially on the internet, that just plain isn't correct about that point. Now, if we don't get all the way through with our ambitious schedule, that's okay, because I'm more than willing to share these slides with anybody who would like them who's attending today's presentation. And if you ever want to give me a call, we can discuss what has been presented in this. We can get to know each other. I would be more than happy to speak with you individually. Without further ado, let's launch into it. Executive disorder. Well, we know how, in Michigan at least, this whole thing started with respect to regulation of our workplaces, which is Gretchen Whitmer, the governor, decided that she had the executive authority, aided, of course, by her very qualified legal team in Lansing, to be able to issue edicts about what people could and couldn't do. There were shelter-in-place orders. There were orders that closed various businesses. However, as you probably know already, on October 2nd, 2020, the Michigan Supreme Court heard this case. It was called Midwest Institute of Health versus Governor of Michigan. A former colleague of mine, Amy Murphy, represented the plaintiff in this case. She did a remarkable job. I was extremely proud to see a former alum of my prior law firm do so well. But the ruling that she was able to win in that particular case for her client, which was a healthcare provider that needed to stop doing voluntary procedures, was essentially to get rid of the governor's authority to issue all those past executive orders. And the Supreme Court, in what was a very, you can't just say it was 4-3, you can't just say it was 7-0, because various majorities and dissenters on the Supreme Court, there's 7 justices there, they objected to various portions of the holding, but the takeaways were as follows. First, they determined that the EMA, the Emergency Management Act, only allowed the governor to declare a state of emergency for up to 30 days. The governor did not have the authority to be able to say, hey, let's take another 30 days after that. And then finally, with the EPGA, which was the other avenue for her to be able to execute authority to give executive orders, it said that the delegation between the legislature was just unconstitutional. In other words, the legislature gave the governor a power that they were not able to give. What's the net effect of this? If you're just a practical person, okay, well, I won't law nerd out too much. The practical effect is that no executive order due to the Supreme Court opinion is effective after April 30th, 2020. They're wiped out. Now, the state of Michigan, of course, reacted in a completely understandable way. They said, hold on a second. A bunch of other states in the union are doing the same thing. We're seeing case numbers explode. What do you want us to do? Well, one of the justices kind of gave him a roadmap. It's a justice where I have to be honest, I don't necessarily agree with his opinions often, but I think he nailed this one. This is Justice Viviano. And he says, wait, actually, yeah, kind of hold up a second. He didn't actually say that. It's a paraphrase, by the way. Now, he didn't, when he said that we needed to hold up, he's not disagreeing with the holding, but he's saying something different. He makes a crucial observation. Okay, the governor tried to do this stuff through these 2 statutes we just talked about. But there are these other public health codes that are also part of the law, established law in the state of Michigan. So doesn't, for example, the Michigan Department of Health and Human Services have authority to make similar restrictions? Couldn't they just do it themselves? That was his point. He's looking at this and he's like, well, okay, maybe the governor can't, but I mean, can't these executive agencies do it? And the answer to that is, yeah. Maybe your reaction is kind of like Jack Black's here, which is, yeah, great. I thought we'd scored a major victory in terms of opening us to just care about safety for our employees. But it meant that, yeah, actually the state's ability to regulate business and to determine how many people could gather together was not eliminated by that Supreme Court. And the reason for that is that we have this particular statute, MCL 333-2253, basically says that the Michigan Department of Health and Human Services, I wrote MDDHS, it's MDHHS, the director can prohibit the gathering of people for any purpose. It gives him broad authority powers during times exactly like this, where there is a crisis of the public health, to be able to step in and say what people can or can't do. And also Miosha still exists, and the Michigan Department of Labor and Economic Opportunity can also enact workplace regulations. So what's that all mean? Well, it means effectively, even though there was a technical ruling that the governor couldn't do it, her executive agencies can regulate us, and what they have to say matters. And of course, who is it that appoints the directors of the various executive agencies? That's right, it's Gretchen Whitmer. I really think that the Michigan Supreme Court case might be useful in the future to curtail future use of gubernatorial power, but it's not really going to make a lot of a difference now. Because nearly the day that Michigan Supreme Court case was decided, the Mdhs and Miosha issued new regulations and new changes, which leaves you wondering what the heck is going on if you're an employer. Well, you guys need to know about those laws and regulations which have come into the breach since then. I'm going to talk about 3 sets of them broadly today. We're going to talk first about the Mdhs gathering rules that were released on the 15th that are going to expire next Wednesday. The Miosha emergency rules, that's the big one for any HR people in this room. We're also going to talk about the COVID immunity statutes that were passed in late October that, quite frankly, there has not been enough discussion about. And if you don't know what those employer immunity statutes do, we need to make sure that becomes a priority for you to learn. We're going to breeze through the Mdhs gathering order fairly quickly. You've seen this chart probably before. This is the one that basically said, hey, we're going to close certain things and leave certain things open. We're going to roll it back, but only for a short period of time. The actual order referred to it as a brief pause, which I don't know if it's a pause for 3 weeks. It's a pretty long pause. I can't say that I've ever held a DVD or a VHS tape back in the day on pause for 3 weeks while I waited to watch it again, but it's just terminology, I suppose. Those are the things that were open. Those are the things that were not open. You've seen this graphic before. You know that. Basically, it does this by limiting when quote unquote gatherings may occur. A gathering is 2 or more people from the same household in shared space. Well, it does not prohibit gatherings if it's consistent with Miosha rules. In other words, the term gathering may not apply to employees meeting together, even if they're obviously not in the same household. Folks in your workforce, a lot of them don't live together. Those gatherings are actually governed by Miosha. So this is mostly talking about gatherings out as members of the public. It doesn't prohibit employee gathering with a customer of the business either. So if you've got, for example, a cashier talking with a person from outside of their household, just a member of the public who's buying something, that's 2 or more people from one household in the shared space, but that's excluded. That's not prohibited by the order. It also doesn't apply to incidental gatherings. If you're just 2 people that happen to be in an airport, for example, that isn't prohibited. And there are certain industry-specific occupancy restrictions which are beyond the scope of today's presentation. We do probably have some restaurant clients and bar clients, as well as some retail and manufacturing companies that are present today. So there is this indoor-outdoor distinction because, of course, it's indoor gatherings that were more sharply restricted. The rule generally is that it's indoors if it's fully or partially roofed, or if there's more than one side enclosed. So basically, if you got anything that's like above a band shell or an amphitheater, you definitely qualify as being indoors. This actually ruined some of the guidance I gave my employers, especially some gyms and some bars back during the first wave, but what can you do? Can't predict the future. You can eat or you can drink in those little igloos or huts, which is a lot of the reason why if you drive around downtown areas in Grand Rapids or Detroit, you see a lot of bars that are putting up those little temporary bubbles for people to eat in kind of an isolated way. It's like eating in the future. It's kind of cool. And then local government offices may remain open under this order. Now, there are also restrictions under this emergency order that require people to wear face masks at gatherings, and it forces business owners to enforce that requirement at gatherings. In other words, when people come into your store, it forces you to enforce that rule. But there are some exemptions. Look at that. There's a cute little mask the state of Michigan is wearing. That was harder than you'd think to put that in the PowerPoint, by the way. I just want a little bit of kudos for that. So we have exemptions. So section 7D of this order, it says business, retail, restaurant, they can't assume that somebody who walks in without a mask on falls within one of the exemptions. There's a health exemption. There are certain age limit exemptions. We can't assume any longer that just because they walked in the door that they are able to take advantage of that. But those entities can rely on a verbal representation. In other words, if you are asked when you go to sit up at an outdoor bar, if the waitress asks you and says, sir, you need to be wearing a mask here. If that person tells you that they're exempt, they have a medical condition that prevents them from wearing it, you don't have to accept that excuse, but you can if you're a business entity, retail store, or restaurant. That is not true to employers, though, and we'll talk about that a little bit later on. Now, children younger than 5 need not follow the mask requirements. We already talked about how certain categories of persons with disabilities allegedly are able to take advantage of the mask requirements. I know there's a lot of debate right now about whether or not there's any actual condition that would actually make wearing a mask dangerous. But regardless, there is a carve out in the law that allows for that possibility. Now, the emergency order from the Mdhs also imposes these contact tracing requirements. What does that mean? Well, it means that if you're a personal service establishment, if you're something like a barber, if you're a tattoo parlor, if you're a tanning place, you have to gather the names of all the patrons that comes in. You have to say when they entered, and you have to take down their contact info. But what's interesting about the new order, and I searched far and wide for an explanation of this, but I couldn't get one, is that restaurants also needed to do this under the old Mdhs order, the one that was promulgated on October 29th. But in the new one, the November 15th order, restaurants and bars are not listed. If you're a restaurant or a bar client, you're still taking down contact information. If that's problematic for you, you don't need to stop. But if that's been a problem for you at all, let's talk about that, because I think there's a very excellent argument that you have that you no longer need to do that. In-home service businesses need to maintain records of client visits. They also need, businesses need to be able to provide names and phone numbers of persons with possible COVID-19 exposure to Mdhs. This is a measure by which the Michigan Department of Health and Human Services wants to be able to contact trace. If you have a case of somebody who came into the store, they want to be able to let you know, and they also want to be able to identify the other people that were in the store at the same time as the positive infected person. You're also obligated to maintain the data for 28 days. You need to keep that data confidential. The contact tracing data the business is taking, that is. And most importantly, there's a prohibition on selling that data or using it for marketing. So the list of the folks that came on into your tattoo parlor, to your bar, to your restaurant, that is not your new mailing list. That violates the law. Now, for employers, Miosha and the emergency rules that are promulgated there are also super important. Now, I know what you're thinking. Okay, Andrew, that was a month and a half ago. We're all over that. A lot of my clients are doing it wrong until we revisit it. And I bet if we go through the next 4 or 5 slides, you're going to find at least 1 or 2 things that you as an employer are not doing that maybe you need to be doing. And we'll discuss some strategies for that. And I just want to let everyone know we're going to be talking about remote work separately because I think it's its own topic. So hold off on that for right now. Now, the Miosha emergency rules that were passed on October 14th, the first thing that they actually required employers to do is to draft, promulgate, and train employees with this written COVID-19 response plan. It's this new document that you have to create. It's an actual policy that you need to keep. It's an affirmative obligation to make this policy. And you need to keep it. You need it to be written. It needs to be given out to employees. They need to be able to access it, and they actually need to know what's in it. Now, the LEO, the Michigan Department of Labor and Economic Opportunity, they have this sample or this template plan, but I always tell my clients, you have to always beware of the boilerplate, right? Law sometimes looks like a series of magic words, but I always fight against that assumption. The fact of the matter is that there aren't any magic words, that policy is only as good as the words that are on it. If you take a template from the internet, you just grab it and you scrub it and you just insert all the new stuff that you want to insert without actually taking account for what's in it or what's not, you're going to have a lot of stuff in there that doesn't apply to your business. And if there's a Miosha inspection later on, they're going to wonder why you're not doing the thing that you said you were doing, even though you didn't realize was in there. You need to take a look at it with fresh eyes. And of course, if you're a business that does not have a COVID-19 response plan because you didn't know that you needed one or you think that it may not have mattered, give me a call, see me after class. We can help. Now, that COVID-19 response plan has to contain this employee risk classification, which is something that's fairly new. So if you drafted a response plan early on in the pandemic, you may not have included it if you haven't revised it since. And basically, it requires you to go and classify each of your employees into one of 4 categories based on the evaluated level of risk that you believe that employee is subjected to by the nature of their job. They don't have fancy names. They're called lower risk, medium risk, high risk, and very high risk. But there are qualifications that Miosha provides in the rules to help you determine which of your classification of employees belongs in each group. This sounds so boring to do. And quite frankly, a lot of my clients, when at least we talked about this issue, they hadn't done it. And they hadn't done it since October 14th. But I'm telling you guys, do it. You really want to do it. There's a reason that you want to do it, which is 1, it complies with Miosha, but there are other reasons that you want to do it too, one of which we'll discuss at the very end when we talk about the vaccine section. But there are also some other good reasons that you might want to do this. Like first, your COVID-19 response plan, it's going to describe the measures that you're going to take to prevent employee exposure. And this opportunity, this COVID-19 response plan, as boring as it may be to assemble, this is really your chance. Why? It is well known that Miosha is stepping up investigation and enforcement of their emergency rules, especially recently and especially in the office working environment. That means that you may have an inspector come and pay you a visit. It may also mean that you get a letter from a Miosha inspector saying they want to check things out. And what is going to be the very first thing they're going to take a look at when they're trying to assess whether or not you're following the rules? That's right, they're going to take a look at your plan. And if it's bad, you've just kind of committed an own goal. It's even worse if you don't have one at all. It's really easy for there to be a technical violation, some small thing that you may have missed, and for an investigator to write that off as de minimis. But when there's a requirement like make a plan and include some of this stuff in it, and you don't have those things in there, you don't have a plan at all, it's a tough one for us to fight. Now, another part of the emergency rules said that employers were obligated to impose infection prevention measures of various kinds. The first one is you must require workers who are sick to not report to work or to work in an isolated location. Now, when they define the term isolated location, they're not really specific about exactly what that means. I think there's an argument that if you have a worker that isn't necessarily working from home, but is working off-site in a single unit, single employee facility, maybe you could allow an asymptomatic person to be able to report to work then. But I think it's a risk because the way that Miosha's emergency rules define isolated location is by reference to that means that you can have an asymptomatic person work remotely. That's what Miosha claims they meant when they said or work in an isolated location. So I think the real hinge is, what does the word report to work mean? Well, it doesn't have a natural reading necessarily, but I do think that it means if they get anywhere near your facility, you are violating Miosha by doing that. And there could be subject to the stick, the enforcement mechanism of the fines that Miosha can assess. Now, Miosha's emergency rule about requiring workers who are sick to not report to work, that also applies to suspected cases, not just confirmed cases. In other words, it applies to employees that may not have their positive test yet, but are symptomatic. You also are permitted to send them home if they report to work and you discover while they are at work that they are symptomatic. And you are able, under the Miosha rules, to permit employees to return only when they've met the applicable CDC guidelines. We'll talk about what those are in our penultimate section. Now, one of the things that we need to do is that we need to direct employees also. We need to tell them that they are obligated to report their symptoms to us as the employer. And that doesn't just mean their own symptoms, by the way. It's totally okay for an employee to come to you and say, hey, there's another employee here at this business that I think he's coughing. He told me he had a fever. He looks very fatigued. There's something that's wrong. Doesn't mean that you have to take that employee's assessment to the bank about the report, but it does mean that you should probably follow up. And it means that if you go to that reported employee and you see, yeah, indeed, this person does have a fever, they're suffering the symptoms of COVID-19, you also are obligated to follow through and send them home. You need to create a policy that prohibits in-person work from employees, and this is the quote from the Miosha rules, to the extent that their work activities feasibly can be completed remotely. What does the word feasibly mean? We'll discuss that a little bit later because that's a whole can of worms. But you are required to have a remote work policy, and Miosha clearly is giving you the guidance that they prioritize remote work over in-person work wherever possible. You also need to increase your facility cleaning and disinfection protocol, and you need to pay special attention, this is the Miosha emphasis point, on tools, machinery, and vehicles that commonly employees use. If you have work trucks, you need to make sure that they're sanitized.
Andrew, we can't hear you. Did you lose your mic? I can't hear you.
Yeah.
It just went dead.
Can you say a few more words, Andrew?
Absolutely. Are we back or no?
There, you're back.
You're back.
Good.
Okay. Hey, it's the miracle of technology, guys. Hey, remember how great Miosha told you remote work would be? Well, yeah, it's going to happen on Zoom calls from now on. It's just, that's the way of life. We got to get used to it. To pick up where we left off, we also need to have this daily entry self-screening protocol, and that needs to include things like the symptom questionnaire. You're used to that. You need to make a case exposure inquiry, whether or not they have symptoms. You also need to ask them whether or not they've had exposure, close contact with any suspected or confirmed cases. The screening can include also things like a temperature screening, and you can also ask them things about travel, and you can also ask them about where they have traveled if that's something you want to do as an employer. The first two bullet points up there, the symptom questionnaire and the case exposure, those are required. The second two they're something optional, something you can do. Now, you also don't be afraid, although this may be a no-no in normal ADA times, if an employee calls in and they tell you, yeah, I'm sick today, and they don't provide you with any more additional details, we are now able to ask them, it is lawful to ask them if they're experiencing COVID-19 symptoms. That's an authorized request we can make. We can ask them to disclose that. And this daily self-screening protocol, how do we document it? Well, it can take a lot of forms. You can do it, there's no official one way to be able to write down the results of the employee daily self-screening, but I used to give the advice that perhaps we could do an implied self-screening. In other words, maybe what you could do is you could just post at the entrance and say, hey, these are the symptoms. If you're coming into work, you're telling me that you don't have any of these. You're not taking an individualized inquiry. Well, that implied protocol, as opposed to the explicit protocol, I think that's no longer viable in any way. Why? Because Miosha is going to make you maintain a written record of that daily entry self-screening protocol for at least 1 year. And of course, if you're working with an implied protocol, there's no record. There's nothing for you written down to be able to prove that you did it. Now, employees that don't answer this protocol, they can be sent home, by the way. So not only is it an obligation for you to do it, it's an obligation for your employees to put up with it. Now, in addition to all that, you might ask yourself, well, doesn't a lot of this stuff follow the ADA? Well, the reason that we're able to get around that and do things like make these medical examinations, like taking a temperature or ask them questions about their medical condition, is because the EEOC has essentially taken a shortcut. What they've said is COVID-19, it qualifies independently as a direct threat. Direct threat is, of course, an ADA technical term, and that provides this shortcut when you have an employee who, for some reason or another, is exhibiting a direct threat. You no longer need to meet that standard required to make a disability-related inquiry or medical examination. In other words, the EEOC is telling you, essentially, COVID-19 is so dangerous that they're going to enable you to do things that you wouldn't normally be able to do with your employees in order to stem the tide of the pandemic. But don't take that to mean that the ADA gives you a blank check, because some inquiries aren't allowed. Don't ask, for example, whether or not family members have COVID-19 or are symptomatic. That violates the Genetic Information Non-Disclosure Act, which is like the one time I've ever given advice about GINA. It's a federal law. But that doesn't mean you can't ask them if they've had close contact. You just need to keep that anonymous. The problem isn't asking them whether they've come in close contact with anybody that has COVID-19 or is symptomatic. The problem is asking them whether that person is a member of their family. Instead, just ask them the basic question: have you been in close contact with any confirmed or suspected cases? That's what you need to know. Not whether or not that confirmed or suspected case is mom or dad. Don't ask individualized inquiries unless you have a specific reasonable belief. In other words, if you have the screening process, that's great, but don't go up and ask an individual employee to do something that you're not subjecting all the employees to unless you have a particular reason to believe that employee currently has a confirmed or a suspected case of COVID. The classic example is temperature checks, right? If you've got a universal policy where everybody that comes in your building has to beep, get the little temperature check to the forehead before you go in, great. The EEOC says that's fine. If, however, you do like a random, and not everybody gets it, but you go around and randomly test people, that's not as fine. Instead, you need to have an individualized reason to perform a test on just one person. So you need to have some evidence they may be symptomatic, for example. And obviously, the ADA also requires you to keep the answers that you get to these inquiries confidential. Don't disclose them. It's common sense, but worth a reminder. Now, as I said, Miosha also has mask wearing rules in the workplace. We're required to require face coverings when employees cannot consistently stay 6 feet away from others, or when they're in shared spaces or in-person meetings. Now, what's a shared space? A shared space is a place like a hallway, a meeting room, a restroom, any place without physical barriers that are separating individuals. So the guidance clarifies for us that means that employees don't need to wear masks if they're in like a single occupant office like I'm in right now. But I also don't need to wear a mask if I'm in an open air cubicle. If I've got a cubicle farm, I got a lot of folks that are clustered around, you know, it's open air up on top. In theory, there could be transmission. The walls are able and sufficient under Miosha's guideline to be able to say, okay, well, that's not a situation where the employee needs to wear a mask all day. Those rules, obviously, those exceptions don't apply if you've got more than one person working in a cubicle. Now, earlier I said that the mask wearing requirement for the DHHS rule, that is exceptions for people with medical conditions, certain ages, that kind of thing. But this is important. The Miosha rule does not allow for any exemptions itself. But again, in other words, the Miosha rule doesn't say if you've got an employee with a medical condition that prevents them from wearing the mask that you're exempted from that requirement. Now, Miosha is a state law and the ADA obviously is a federal law, so there's an implied exemption, but Miosha is very clear that you need to actually dance the dance of the reasonable accommodation process if you want to be able to exclude an employee from wearing a mask. So you can only exclude an employee from wearing a mask in those shared spaces if the ADA mandates that exception because of the health condition of the employee. And you need to treat a situation like that like any other reasonable accommodation request. You need to go through the steps. Obtain the documentation from a physician saying, yeah, this employee does have something that would make wearing a mask difficult. Consider other accommodations. You may consider remote work, for example. Instead of saying don't wear a mask while you're at work, maybe you send them home and have them work from home if that's possible. And then document the accommodation that you provide. You have to do those steps. You can't just take their word for it. That's Miosha's perspective, different from the standard promulgated by DHHS. Third thing we're going to talk about here today is immunity. Now, when you're thinking immunity, especially in a pandemic, you're probably thinking like the sexy kind of immunity, right? Like the kind of immunity a vaccine is going to give us. It's going to defend against the virus. Alas, I'm a lawyer, not a doctor, so that's not what we're talking about today. We're talking about the thoroughly unsexy legal immunity. But just because it's unsexy doesn't mean it's not useful for you. And I think it actually is very useful because remember how I said Miosha and the DHHS, they have rules, they're going to cite you, they're going to fine you if you don't do the right thing. Well, this is kind of, that's the stick of compliance. This is the carrot of compliance. This is the incentive for you to want to play ball and fulfill your obligations under those particular restrictions. There are 3 bills in this package. The first is a personal injury immunity from covered COVID-19 claims, usually useful for members of the public that would come into contact with your employees if they may get sick. HB 6031 provides employer immunity based on Miosha, and HB 6032 provides employee protections. So we have public tort protections, employer protections, and then employee protections in these 3 bills. HB 6030, who's protected by this one? Well, anyone is actually protected. Individuals, businesses, government entities, schools, nonprofit entities. And what are they protected from? They're protected from personal injury claims that are, this is a quote, arising out of, based on, or in any way related to exposure or potential exposure to COVID-19 or to conduct intended to reduce transmission of COVID-19. Classic example, what are we talking about? You own a retail store. A member of the public comes into your store. You've met all the obligations, you've met all the Miosha guidelines, you've met all the retail guidelines, you've met the occupancy limits, your employees are wearing masks, everything's going great. Nevertheless, one of your employees, they slipped through the cracks, they had COVID, they didn't know, they were working, they were asymptomatic, the member of the public gets sick. Well, this immunity statute says that you cannot be held liable for that as the business owner, so long as, and this is the hook, you're in compliance with all federal, state, and local statutes, rules, regulations, executive orders, and agency orders related to COVID-19. In other words, you play ball with Miosha, you play ball with DHHS, then you're golden. You get extended this level of immunity. Perfect. There's also employer immunity. This applies both to public and private entities. And what are we protected from? We're protected from any liability that may arise from an employee's exposure to COVID-19 in the workplace. But provided what? Provided that we followed all the Miosha guidelines. Miosha and DHHS are essentially acknowledging this. Their guidelines aren't going to make sure everybody's 100% safe. But if you follow their guidelines, they're telling you you're going to have immunity from various causes of action, especially those causes of action that are based on personal injury, negligence. It does not provide immunity from worker compensation claims, very notably, and it does not provide immunity from statutory claims. So if you discriminate against an employee for something on that basis, and you make some sort of discriminatory application of your rule on the basis of some protected characteristic, the fact that you follow the Miosha guidelines won't save you from that, but it will save you from the nightmare scenario, right? Which is employee A gets COVID-19 from employee B at work, and then maybe maybe employee A goes home and gets grandma sick, and maybe she passes away. We don't want to be liable from the fact that the exposure happened at work. And this enables us to take advantage of that so long as we follow the rules. We also have this immunity statute for employees. Now, this applies just to employees that all employees are covered by this, and except those who work exclusively from home. This is the other side of the coin. And what are employees protected from? Well, they're given essentially protected activity status, like a person who is protected by Title VII, person who's protected by the NLRA, a lot of the other employment discrimination statutes. They're protected from retaliation for complying with something called Section 5, opposing a violation of this particular statute, or reporting an employer health violation based on COVID-19. And what does Section 5 say? Section 5 is an attempt basically to incorporate the then existing CDC guidelines. It says, if you test positive, if you're an employee who tests positive or who displays the principal symptoms of COVID-19, you are not allowed to report to work until 24 hours have passed since fever without medication, 10 days have passed since symptoms first appeared. We know the rigmarole. It also says that an employee who has close contact will not report to work until the quarantine period has expired. So how does the immunity work? The immunity says basically, those are the restrictions on employers. And if the employer tells you, whatever, come to work anyway, or you're fired, or whatever, come to work anyway, or you're going to lose pay for the time, or do anything, or they force you to work, or they exempt you, for example, from getting the requisite amount of FFRCA leave, well, then you're in a situation where Section 5 has been violated, and the employees now have an affirmative new claim against you. Now, Section 5 doesn't apply to certain employees, including healthcare workers, first responders, child care workers. So it's not all employees that are covered by this, but this puts the teeth in. The CDC's guidelines were guidelines before, and the Miosha obviously cited you for having conditions where an employee could have been working while sick. This is the actual stick that would hit you as an employer if you actually allow someone to work while they are sick. You follow the guidelines about isolation and quarantine, or you are going to be subject or could be subject to this special civil cause of action in addition to all the other damages that you may have to pay. Next topic we're going to talk about today is an Ffcra update. You all know what the Ffcra is. It's the law that was passed back in February. It was the second of the 3 major coronavirus bills. And this is the one that basically entitled employees to paid leave if they fell into one of 6 eligibility categories. You guys all know what those categories are, so we're not going to rehash them. But this is the question I'm mostly getting asked. The leave requirement provisions, the Ffcra, it's set to expire on December 31st. In other words, it's only supposed to last, those employee leave entitlements are only supposed to last until 2020. Of course, the question I have for you is, did COVID-19 expire? Well, look at the cases. The answer is most definitely no, which as an employer is definitely generating some questions. What does that mean? Case counts are going up, but now the leave requirements are going away? What's going to happen? Well, employers want to know 3 things in my experience based on this. The first one, you guys want me to be able to have a crystal ball tell you whether or not the expiration deadline will be extended. We'll talk about what I think about that, although there's no way we can know. The second thing is, you guys want to know what changes have been made to the available exemptions. There are certain exemptions from either some or all of the leave you must provide for certain categories of employees. You do know those have changed recently. We got a new regulation at the end of September. We'll talk briefly about that. And then we also want to know, okay, well, how did the Mdhs and Miosha emergency orders impact leave availability? Because most employers aren't thinking about that at all. It's not intuitive. As for the first question, are the leave entitlements going to be extended? I have no idea. neither does Donald Trump, and neither does Joe Biden. We're just not sure yet, because political developments are tough enough to protect. So if I get out my magic 8 ball, I can think about what would need to happen for those leave requirements to be extended. First thing we would need to do is we need to do it legislatively. The president can't just decide that it's going to happen and make it happen. It's also true that the current House, the House of Representatives, led currently by a Democratic majority, they probably don't want to give President Trump a send-off win by conceding to something on the way out, just as they're about to get their guy in office now that it is virtually certain that Joe Biden will be the president come late January. It's also equally true that the current Senate, which is a Republican majority, doesn't want to give the incoming Biden a win. In other words, they don't really want a first plank of the Joe Biden plan to do something that benefits all employees across the country. So there's this tension that's there. Now, the House and the Senate, they both agree we need a new coronavirus relief bill, but they have a wild divergence in the size. The Democrats want a bill that's about $2 billion in total relief. The Republican majority, led by Mitch McConnell in the Senate, they want one that's really strictly targeted, that's around $350 million. Big difference. Also, we have this additional complication. Nobody knows who's going to win the Georgia Senate runoff, so we don't know who's going to control the Senate after January. Also a big problem. Now, there were a bunch of senators and congressmen that got together from both parties, and they put together this bipartisan commission. They announced this thing called the COVID Emergency Relief Framework. And basically what this was a compromise proposal. It was $900 million, more or less, included the things that you can see in teeny tiny print on that slide there. But on Tuesday, when this thing came out, Mitch McConnell announced that he wasn't going to support that, and instead was going to rely and say, no, the Republican proposal, $350 million one, we're gonna stick to that. Is that pure negotiation? I don't know. I do know that there's one last chance for them to be able to fit this stuff in before the end of the year, which is they have to put together this thing called the Omnibus Appropriations Bill. It's the super long, mega boring, basic budget package that gets passed absolutely every year. A ton of stuff goes in there that's not related at all to the budget. It's possible that an Ffcra extension could be slipped in there, because I don't think either party really fundamentally disagrees about it. It's just a lot of political gamesmanship going on. So what do I think is likely to happen? Again, I don't know. This is a magic 8-ball moment, but it's a little bit of a hazy guess, but don't hold me to it. I think, though, that one of two things is true. Either the appropriations bill will extend the Ffcra, or it'll get enacted by some other means at the beginning of next year. What that means is I think that the Ffcra extension is coming, but we need to at least get ready as an employer for the possibility of there being a gap, a period of time between December 31st and whenever this hypothetical new bill extends the Ffcra protections. We need to know what we're going to do with people that fall into one of those 6 qualifying conditions during that period of time. We need to come up with a plan now to cover that gap period. We may not need to use it, but we're going to need it if we do. Now, it doesn't need to be paid leave. It doesn't need to be the 80 hours / 10 weeks of EPSL, EPFML. It doesn't need to be anything at all, because in theory, during that gap period, there's no legal entitlement. There's a very practical entitlement, which is you're going to have a lot of employees that are going to miss time because of COVID. We will need to provide some sort of absence control measure in case those leave extensions aren't, in case the leave requirements aren't extended. We need a plan now. We also want to know what changes have been made to the available exemptions. Now, broadly, you know this, the Ffcra, it has 3 employee exemptions: the small employer exemption, the healthcare provider exemption, and the emergency responder exemption. Now, on April 1st, way back in the beginning of this, if we can think that far behind, the DOL released this regulation that helped us to interpret the scope of them, and everybody thought that that was groovy. But freeze, everyone. On August 3rd, the Southern District of New York, they issued this nationwide injunction because of the court case. And they said the healthcare provider exemption that the DOL said, the way that they interpreted it, that is way too broad. The DOL's earlier exemption said basically, if you're a healthcare employer, you can exempt your employees. And the court said, not so fast. The assessment needs to be on what the employees are doing, not what industry the employer belongs to. Well, what does that mean? Well, at the end of September, the DOL issued a new regulation that incorporated that ruling on in. The bottom line, the small employer and the emergency responder exemptions, they're the same as they've always been. They're the same that you've gotten advice about 1 trillion times already. The healthcare exemption has changed. It's no longer employer specific. So just because you run a medical clinic, you run a hospital, you're HR for a medical group, that doesn't mean you're per se able to exempt any employee of your organization. Instead, we now make it available only to the employees who are capable of providing healthcare services. That includes things like diagnostic services, preventative services, treatment services, other integrated and essential stuff. The result, a medical practice employer, you can claim that exemption for things like doctors, nurses, phlebotomists, but you can't, for example, for HR people, for billing specialists, for CFOs, executives. Don't you all feel betrayed? The third thing, FFCRA leave eligibility. You can already recite the 6 qualifying reasons by heart. I'm sure you can. Those aren't any different, but what was that first one? Well, the first one was an employee is eligible for leave under the FFCRA, emergency paid sick leave, if the employee is subject to a federal, state, or local quarantine or isolation order. Think back though. Do we have any new federal, state, or local quarantine or isolation orders? Well, I know one we definitely have, which is House Bill 6032's employee protections about quarantine and isolation, right? Think back to what we just thought about. HB 3062, essentially, what that does is it reaches into the FFCRA and it says, if an employee needs to isolate or quarantine under HB 6032, automatically then that employee is likely eligible for emergency paid sick leave. So again, if you fall within, if you have close contact, if you have a confirmed case, if you have a symptomatic person, even if they wouldn't have been by a plain reading of just the FFCRA eligible reasons, because HB 3062 prevents that employee from reporting to work, that's what it prohibits, then that becomes a qualifying reason for that person to receive paid leave. The next section we're going to talk about, it involves remote work. And I think that remote work provides this really huge conundrum for people, and I get questions about remote work all the time. First, we need to ask ourselves, do we even like to work from home? Well, 18% of people do it full time, 77% say they're more productive when they do it, 33% said that they keep set working hours, which is the best way of staying productive. In other words, they work from 9 to 5 just as if they were in the office. But 37% said that the key to productivity was taking frequent breaks, which doesn't necessarily sound like the key to productivity to me. Companies that promote remote work have a 25% lower turnover rate. That's good. But 54% of IT professionals think your remote work employees provide the biggest security risk of anyone, which is bad. 99% of people like doing remote work and want to consider doing it at least a little bit. That's good. But some studies show increased productivity from remote work. Some studies also show your employees are less responsive. And I think there are a lot of employers out there that know that story. I hear from employers all the time. We were at a certain level of productivity, and then once COVID came, everything hit the fan. Things aren't as good as they used to be. What are we going to do? So in terms of what we think about remote work, we're all asking ourselves this question. Is it good or is it bad? Is it something that we like? Is it something that we don't like? What are we thinking? And the answer is going to be different from each employer, and the answer is going to be a lot of ambiguous for many employers. You know, I think that the actual division comes best from, there's a pop band, Fifth Harmony. They have the song Work From Home. I think the rule that they give out in that song and the lyrics is exactly the right rule. You don't gotta go to work, but you gotta put in the work. Remote work only works if your employees are productive, right? On the other hand, remote work has some potential pitfalls. And that's a reason why you may not want to do it even if productivity is the same as it always has been. That's supposed to be an animated GIF of the video game Pitfall, thank you very much, not displaying properly, such as the vagaries of Zoom. Remember that if you have remote work, you have these dangers with FLSA covered employees, especially ones that are overtime non-exempt or ones that work hourly. This is the same challenge, by the way, that's presented back with mobile use. And basically what it is are your employees going to end up working off the clock because they're working in a new place where they don't need to be confined by the strictures of 9 to 5? Also, if you see an employee lingering around, he's hourly or overtime non-exempt, and you don't want to pay that employee overtime, if you see him hanging out after 5:30, you can tell him, John, go home, and then you know he's off the clock. Well, not so with remote work. This means that monitoring of employee hours, you need to keep doing it, and that presents a new administrative burden for you and a new potential litigation against you if you screw it up and do it wrong. Employee working hours are likely to deviate from 9 to 5. You also have this remote work accommodation danger under the ADA, which is coming up a lot. Remember, there's this pre-COVID debate about whether or not remote work can be a reasonable accommodation. That was the thing that we talked about a lot of different times. We talked about that for a long time. Now, there was a circuit split, and a lot of the circuit said, yeah, remote work, telework, it's not a valid reasonable accommodations. Other ones said that it was. But now that we have a lot of folks remote working, did we just lock ourselves in to offer that as a reasonable accommodation after the pandemic ends? Well, the question gets solved if we ask ourselves the basic ADA question. Can remote workers perform all the essential job duties or not? If they can, then remote work is possible as a reasonable accommodation. If they can't, though, then it's not a reasonable accommodation at all, and you don't need to tolerate telework. But the big thing is EEOC has weighed in. And they said, just because you prior were offering remote work as a consequence of the pandemic does not automatically mean that you need to offer that as a reasonable accommodation for employees that request it by means of a disability after the pandemic is over. Instead, the only advice I can give you is the generic advice that makes the most sense. Consider future requests with fresh eyes. Think about it renewed after the pandemic is done, stay at home is over, the Miosha rules are rescinded. Think about those requests to work from home, brand new, and evaluate it from the beginning. Engage with them in the interactive process, and most importantly, check that job description. If you end up saying, yeah, we can't actually tolerate remote work anymore, but the job description says that you easily could, and they used to do it during the pandemic, you've got yourselves a really difficult situation. I want to talk really briefly about the requirement to work remotely. We're not going to hit the rest of our topics, but I will share these slides with anyone who wants them, and I also will stick around for questions. But this question was so common, let's just knock it out right now, which is, do our employees need to work remotely in Michigan under the new Miosha rules? And you'll remember that we used to work in this vacillation between should and must back when we were in the executive order zone. It was really confusing. Was it recommended or was it required? Well, the Miosha regulations, it's much more clear, except it's not clear at all. It's giving us contrary signs, and we need to address that. The Miosha emergency rules, we talked about this when we talked about the rules themselves. They say the employer shall create a policy prohibiting in-person work for employees. Scary, but clear. But then that sentence ends, to the extent that their work activities can feasibly be completed remotely. Feasibly, that's extremely confusing. It's tragically unclear, in fact, and leaving you looking as confused as Fry from Futurama right there. Feasible, if you look it up in the dictionary, says possible to do easily or conveniently. That seems to suggest there's a lot of leeway, and if a person's job would be hampered doing it remotely, we can exempt it. But Miosha released this FAQ shortly after the promulgation of the rule that said they defer to the employer's judgment about whether or not remote work could be done, whether work could be done remotely, a particular job could be done remotely. They ask you to make the assessment, but then they defer to your judgment. Then it got a little bit more restrictive. On November 6th, Miosha said, the responsibility to maintain a safe workplace is paramount and strongly suggests that employers should allow employees to work from home if possible. The document contradicts itself internally. It says, employers should only permit in-person work when attendance is strictly required, which means they're unable to physically complete required job tasks from a remote setting. It does not mean that an employee will merely result in decreased productivity when working remotely, or because there may be additional costs involved with setting up that employee to work remotely. Uh-oh. Well, it gets even worse, because Miosha Director Bart Pickelman on November 10th, he said in a webinar that he gave, all workplaces in Michigan must promote and continue remote work to the absolute maximum. Doesn't sound like the feasibility standard anymore. And it also announced a state emphasis program for office workers that focused on settings like, the conventional office environment, where it addresses the need for increased vigilance, education, and enforcement on remote work policies. So they've put a target on your back, and they've said, we're going to be looking into this. And then they revised their frequently asked question to get rid of the deferential standard to employees. And now it says they're obligated to demonstrate infeasibility of remote work. What does that mean? It means that people need to report for in-person. If you're going to have a person report for in-person work, you need to have documentation that they can look at that states why that person needs to be present in the workplace. And it also needs to state that the work can't be performed remotely. That is not a feasibility standard at all. That is something else. They're not going to give you deference. And that means, guys, think Miosha is serious about this remote work requirement. We need to take it seriously. Last slide of today, I promise. What do we do? The first thing we need to do is the HR team and the ops team, they need to get together. They need to go position by position, job classification by job classification. We need to ask ourselves a question. The question I propose starting with is, why can't this employee perform all the essential functions of his or her job from home? Start with the assumption that they're going to require you to do remote work and try to find the infeasibility. Consider that risk assessment status you need to do as part of your Miosha response plan. Interesting. Those two kind of have to align to a degree, don't they? Because of course, the degree to which that employee is exposed to risk is going to contribute to the feasibility analysis. All the more reason for you to actually do the classification by classification risk assessment. If you conclude that person can't, you need to come up with the reasons why they can't. Can't just be a feeling, needs to be concrete. Draft documentation of those reasons and inform the employee about what they are. And don't include these reasons in the documentation. It's going to make you less productive. It's going to make it more expensive. Miosha won't care. Those are going to be red flags. When making the assessment, think through the traps Miosha is going to set for you. Does your assessment of the essential job functions, when you got down and you said, could we do this remotely, does that conflict with what the job description says? Because that's going to suggest that you were being less than genuine when you were making the assessment. Have you allowed employees in that classification to work from home as a reasonable accommodation prior to COVID? It was a reasonable accommodation before, that's a per se admission that that person can perform the essential functions of their job from home. So why can't they now? Miosha is going to know. Then look at this. Do materially similar job classifications work from home? If they do and you can't distinguish, even though the job classifications are technically different, you've got a problem there. Ladies and gentlemen, we weren't able to get to the quick tips and we weren't able to get to the vaccine section, but I very much appreciate your patience and your time today. I will share this presentation with anyone who requests it from me. We can do that over email, or I can maybe even put together a blast if the recipient list can be shared with me. And I will stick around as long as is necessary for anybody that has any questions about anything. So thank you all for your time today.
Andrew, if you are willing, and people want to stay on, can you go through the rest of the slides so that we can have that as the recording, and then we'll make that for distribution as you mentioned? Okay, great. One pressing question that I would like to ask you that came up in the chat is, how would an employee be able to prove that they got COVID from work? I know that we get that question quite a bit, and in your professional opinion, what would be the onus or the measure in which they could?
Well, a couple things about that. First of all, the issue of the word prove is very difficult. And that's the case, by the way, with any Miosha issue that's ever involved communicable disease. The pandemic is very broad, it's very widespread. How would they prove that they got it at work? Well, I think the better way of asking the question is, if the allegation is raised, if Miosha is going to come because they think they may have gotten it at work, are you going to be able to take advantage of the immunity statute by proving that you followed all the regulations? In other words, the process is the result. We could be equally safe from nobody ever getting sick at work as we could from following all the rules to ensure it as best we can. So I don't think there is any way to prove it, but what we need to avoid is being in a situation where we get ourselves in the position where Miosha is asking us to demonstrate that they didn't, and we can't prove that we followed the regs. I think that's the true disaster.
Okay. I would also like to mention that as part of the additional slides that Andrew's going to finish up for those who want to stay on, a common question we're getting to is testing and the availability of testing. You know, how is Spectrum Occupational Health partnering with employers to do that, and what other resources are available to employers? So we know that there's a slide in pertaining to that. That's Helix here locally, Trident. There's several of them that we have on the list that you as employers can reach out to and determine which partner is best for you. But that's a common question we're receiving as well. So without further ado, I'd say those who want to hang on, please hang on. If you are departing from us, we want to just thank you for your time. We look forward to having you on January 21st for the next topic. And again, we will make sure that the distribution of this gets to all attendees.
Thank you so much for all your time if you're leaving us for the moment. And please check out the recording once we put it on up. I guarantee you there's some good tips to follow. You want me to just launch right back into it, or do we have anything else question-wise we want to clear up before we kind of go back through the intermission?
There's a few other questions that we will make sure that we just post as part of the follow-up, and we'll separately get answers from you on those. Okay?
That's great. The next section is, I would say, after remote work, the second most frequently asked topic of concern for employers. Again, I call it just the vax, ma'am. I'm so sorry. What a terrible pun. To really drive it home, there's a picture of Joe Friday wearing a Christmas hat. It's what you all wanted. It's what you all needed. And here we are on the eve of, at the very beginning of the month of December, as we begin to go into the new year, 2021, it appears that a vaccine for COVID-19 is very, very close to public consumption. And hallelujah. We are all so thankful that that possibility is coming soon, because quite frankly, that's going to be one of the few ways that either we will be able to get back to normal practically, or at least we'll be able to get back to normal legally, to the extent that normal still means what it used to, of course. Now, there are 3 vaccines, as I understand it, that are close to being available in the United States. I stress I'm not a doctor. This is information that I have learned through various forms of public consumption, but nevertheless, in summary, here they are. First, there's Pfizer's, that's something called mRNA based. So that's a new method of administering vaccines that there's been a lot of testing done on it. It's been hypothesized, but as I understand it, mRNA vaccines are not something that we've ever used before. It supposedly is 95% effective. It is currently pending FDA emergency use authorization approval. And get this, the UK has granted it emergency use approval. In other words, there will be people in the UK who will begin to become inoculated with the vaccine, I think as we speak is the issue. Now, you should also know with all these vaccines, that doesn't mean because the UK did it first, they're going to get all the doses. Because all of these vaccine manufacturers, they were given a really nice bonus by the US government associated with the vaccine development program, which is this process of advanced manufacture. What that basically means is they bought the doses of the vaccine, a lot of countries did this, including the United States, before they knew whether it would work. The idea being, if it didn't work, they'd just trash them, but they wanted to incentivize those manufacturers to ramp up production now. In other words, the UK's vaccines, they've already been bought and paid for, and we have our own from Pfizer that the United States does that we have bought and paid for. They're waiting for us as soon as that emergency use authorization is granted and the other legal loopholes are cleared. Moderna also has one. It is also mRNA based. It's supposedly 94.1% effective. They applied for FDA emergency use authorization on Monday. And then finally, we have one from AstraZeneca, which is the Oxford University collaboration. That's a different kind of vaccine called a viral vector, which is more common. We've used viral vector vaccines before. It supposedly is 90% effective, although there's a little bit of uncertainty about that number. But it isn't ready to have an emergency use authorization application filed here in America. So it will be the most distant of the 3 to come. Now, before anybody in the US can get them, the FDA needs to do this thing. We need to grant the emergency use authorization. It's a prerequisite. Now, that could happen in December for Pfizer and Moderna's vaccines because, as I said, they've already applied for that, and the turnaround is intentionally going to be extremely thorough but extremely quick. And as I said, manufacturing has already been rolling, so soon after we get the approval, we'll begin to actually roll out the vaccine. How would that happen? Well, the CDC is going to make a list of recommendations about who should receive those vaccines first. They're going to consult with the National Academies of Medicine when they do that, which is as I understand it, basically an informal college of a bunch of physicians that get together and they meet and discuss things like this, experts in their field. They're going to make recommendations about how exactly these vaccines should be rationed to the public, because we're not going to have enough for everyone to get them at first. The United States Department of Health and Human Services director has also gone on the record to say that under at least the Trump administration, HHS, state governors will have the final say in determining the vaccine priority order in their own state. The vaccines will be distributed to the state will come up with the method of being able to get them out to the public using both public facilities and private facilities, and the state will get to decide who is able to get it in what order. Now that leaves a ton of questions about how this is all going to happen. There's a lot we don't know. First, I guess, Does the federal government have the authority to make everybody get the vaccine? We actually don't know that. As I understand it, even during the flu pandemic, there was never an exercise of federal authority to make, this is the flu pandemic of 1918, to make people get the vaccine. So we just don't know. Can the federal government do it? Not really sure. What we do know, and what a lot of people don't know, is that all states already have some mandatory vaccination laws for children. In other words, all states say all children need to be vaccinated, but they're subject, of course, to various religious and medical exemptions. You can be exempted from that requirement to get your children vaccinated if you have certain kinds of religious or political or ideological objections in other states too. There have been some additional exemptions that have been added legislatively on those states that mandate vaccination. But we also need to confront the fact that adult vaccination is not something that states have a big custom of ever making mandatory. They're rare and exclusively limited to specific situations when they've been used in the past. Now, every single state, I'm sorry, that's not true. It's most states, not every single state. Michigan is included in that most state category. They have this emergency mandate statute that essentially says a state agency can require vaccination of the public. They can make taking the vaccine mandatory even for adults. They have the option, the states do, to be able to do that. Those statutes mostly come from the mid-40s and the mid-19-teens, when there were two pandemics, the flu pandemic, and then there was a less serious flu pandemic that occurred after World War II. And during that period of time, these departments of health and human services, or the equivalent department in other states, they were given the authority to be able to say, under these conditions, you are able to exercise authority to mandate people to get a vaccine. So we don't know if the federal government can. We're pretty certain that the state governments can. But we also have all these practical issues to solve. The easiest one is, how are we going to transport and distribute this stuff? Two of the vaccines, the Pfizer vaccine and the Moderna vaccine, require the vaccination tubes themselves to be super cooled to an extremely low temperature. Now, this is an engineering problem, and I don't know, call me crazy, maybe an unbridled optimist. I bet that we have minds in this country that can figure that out. And certainly Pfizer and Moderna already have some proposals about how to make that happen, but it certainly is going to make it more difficult for everybody in the first wave to get a mRNA vaccine if they need to transport them in trucks that are chilled to 80 degrees below zero or whatever it is that requires the molecules to remain stable. We also, of course, have issues with safety concerns and monitoring. These are all vaccines that were approved under, or will be approved, we expect, under the Warp Speed program. And again, two of those vaccines, as I mentioned before, are not common methods for vaccination. I don't think that you need to be particularly politically or ideologically fringe to have at least some hesitation about taking a vaccine in that circumstance. Although, you know, I think the predominant view is that we need to trust the scientists that have done the work, and certainly the standards have been very rigorous and very large sample sizes have been used to test these vaccines. Regardless, we will have members of the public that will just say, I don't think it's safe enough yet, I'm going to wait. We also have the issue of public pushback. We talked about religious exemptions and medical exemptions. We also talked about safety concerns, but it's no secret, and I pass no judgment, I make no statement about it either way. There is a large anti-vaxxer movement in this country that believes that vaccines are either unsuitably dangerous or that they are outright harmful. It is possible that there will be people who are mandated to get the vaccine that will assert a political or ideological objection, and then the state's going to have a tough time deciding what they're going to do with those folks. But what you really want to know, obviously, as HR people and as employers, is you want to know whether or not you can add this to the work rules. You want to know whether you can require employees to take the vaccine. Okay, well, we actually have a little bit of an answer for that. There's some precedent. And it comes from the realm of employer-mandated influenza vaccine requirements. So the flu vaccine. We already have, and this started in the early 2000s, so before I started practicing law, we already had certain instances where individual employers were saying, if you want to work here, you got to get the flu vaccine. It started in the healthcare sector because obviously there is the issue of exposure to possibly immunocompromised patients, but then it extended to a lot of other employers too. Well, what does the law say about that? Well, the law says, and this is a general rule with a bunch of contours that will also vary from state to state, unless the employer is in a state that has prohibited mandatory vaccinations. I believe to date, Oregon is the only state that has. An employer can require employees to receive a vaccination as a condition of employment, as long as there are exemptions that are offered for individuals who have medical conditions that may subject the employee to a greater risk from being vaccinated as they would have from contracting COVID-19, or if they issue religious objections. Certain religions, you may or may not know, have a tenet of their faith to not take medications like vaccines, and that is a sincerely held element of their religious belief. Well, remember, this isn't the government doing it. This is a question about employers doing it in the private sector. And employers in the private sector, they don't have a constitutional concern. So the First Amendment isn't exactly going to form a hurdle for them. The Establishment Clause and the Free Exercise Clause are not going to be big hurdles for an employer that wants to mandate all of its employees to receive a vaccination. But we do have the ADA and Title VII. And both the ADA and Title VII have at least theoretical provisions within them that say that you need to offer some sort of reasonable accommodation, the terminology is the same in either context, for an employee that has a medical condition that it needs to have them be exempted from vaccination, or an employee that has a religious objection. You need to be able to make the reasonable accommodation analysis. Now, that doesn't mean that that a religious objection or a medical exemption, medical condition that would interfere with getting vaccinated, it doesn't mean that those people are per se exempt from having to get the exemption or having to get the vaccination. But it also doesn't mean that you can per se force them to either. You need to go through that reasonable accommodation analysis. Now, remember that both reasonable accommodation analyses have an undue hardship standard. If the employer can prove that the requested accommodation, so for example, if a person comes to you and says, I have a disability, here's the documentation of that, and as a result, I want a reasonable accommodation of being exempted from your employer vaccine requirement, you can take a look, and if the circumstances are right, you can say, no, giving you that exemption would present an undue hardship to our organization. Now, it's easier to prove the undue hardship standard for a religious objection than for a medical condition because the analysis is a little bit different. A undue hardship for a religious objection requires a way lower burden for the employer to prove than the ADA version, the medical condition undue hardship analysis. You guys are HR directors, you guys know that. But both of them might be easy to prove. In other words, you may be able to prevent people from using either of those exemptions at your employer, given the gravity of the pandemic. Because that's one analysis in the undue hardship, right? Not only is it how difficult will it be for you to give them the accommodation, but also what conditions will that place your workplace in? Put it another way. Consider it this way. Suppose that a nurse has a religious objection to receiving the COVID-19 vaccine, but also consider that the nurse's job is working either with the elderly or with the immunocompromised. I think it would be pretty easy in that circumstance for the employer to be able to say, exempting that person from a vaccine requirement, even despite the religious objection, that presents an undue hardship. We can offer other possible accommodations, but in other words, we may be able to transfer you, you may be able to do your job remotely through a proxy, but we're not going to allow you to have that one. You either need to get the vaccine or we need to come up with something else. The undue hardship analysis might be easy in the vaccination context. But beware. If you are a unionized workforce and you have collective bargaining agreements that cover your employees, please be aware that there is good case law from the NLRB that says that you have a duty to bargain a mandatory vaccination law for unionized employees. Again, if you're at will, if you're not covered by a CBA, if you don't have a unionized workforce, you get the discretion on your side, subject to those exemptions. But if we're in the CBA context, that's a place where you absolutely 100% need to get labor counsel involved to assist you through it. Now, obviously, there is another issue that's lurking behind all of this, which is that it's no secret, and again, I pass no judgment, there is a large movement of people in this country that just plain aren't going to trust the vaccine, not at first or maybe ever. That is also going to pose a problem for you, because for private employers, if you make a mandatory vaccine requirement, neither Title VII nor the ADA is going to require you to accommodate a person that has a political or an ideological objection to becoming vaccinated. State laws may be different, but here in Michigan, at least, the federal laws are the only ones that would speak to it. and neither of those statutes is going to pose any problem. So what does that all mean? It all means that you need to start planning what you're going to do now. I propose, and this is just an Andrew Cassini suggestion, given everything that I've read and working my way through it with employers that have already come to me with this, I propose a 6-step procedure for everyone to follow. And I do think that everybody needs to think about this inevitability, because widespread rollout of a vaccination is going to happen. And it is going to impact your employer because, of course, it's going to impact your workforce because they're members of the public. So to the extent that we need to participate or make decisions in that, we need to decide what our plan is. So these are the following 6 steps as I see them. Step 1, we decide whether or not we will mandate vaccinations for employees that are working on site. It's very important if we decide yes at this initial junction, yes, we are going to require our employees, once the vaccine is available, to be able to get it. We're going to require that. We do need to be monitoring and remaining flexible with federal or state laws as they change. Because as I mentioned before on the last slide, like it or not, and regardless of which camp that you are in, this country shares equal residency of both anti-vaxxers and people that 100% believe that this is the way through the pandemic. Meaning, there is likely to be public support behind laws that prohibit mandatory vaccination laws, and there will likely be a backlash against the imposition of those laws. What you need to care about as the employer is whether or not they get passed. So we need to stay flexible. We need to make our decision as an employer, but we need to be mindful that we may not be able to carry that through once these vaccines become more available. Step 2, after we've made the decision about whether or not we'll mandate vaccination, if we will, we need to come up with our exemption policies in advance. We need to have an exemption policy for religious objections and for medical objections. That doesn't mean that we need to allow everyone with a religious or a medical objection to just not get the vaccine but be treated the same as everybody else. But we need a procedure for them to follow where they can make us aware of their need for a reasonable accommodation and the factors that we'll evaluate when we're making the decision whether or not to grant it. We just need to make those exemption policies clear in advance. We also need to make a decision about whether or not you're going to allow employees that have ideological or political objections to also make a reasonable accommodation request. Federal law doesn't mandate it, but you as the employer can decide you want to do it. Step 3, regardless of how you're going to, whether or not you're going to mandate vaccinations, think about how you're going to prioritize your employees for vaccination if the federal government or state asks you for input. Whoa, you might be thinking this is crazy. I don't know, maybe it is. But we have an unparalleled distribution problem in this country. We don't have enough vaccines for everyone to get them at first, and we probably won't have enough vaccines for everyone in this country to get them who wants them, or who will take them, I guess I should say, until 3/4 of the way through 2021 by even the most optimistic estimates. How are they going to decide what the priority is? Well, the CDC is going to take it from a 10,000-foot view, regardless of whether or not it's the Trump administration making the recommendations or the Biden administration. They're going to zoom out and they're going to say, well, who are the people who should get it first? They'll probably make some based on demographics, if they belong to areas of risk, if they are elderly, if they have medical conditions that have been proven to make people more likely to die from COVID-19. But they will also probably consider occupational requirements as part of that process. And the CDC doesn't know what each of the employees at your work site do, what they do. They're just going to say employees that are maybe, I don't know how it's going to all happen, it's yet to happen and it's completely new, it's never happened before. The CDC might say anybody that routinely is in contact with people that are confirmed to have COVID-19. Well, you, by virtue of their work, anybody who in the workplace is going to have contact with people who are positive for COVID-19. Well, you as the employer are going to be the one to be able to identify those folks, because a lot of your employees are going to be champing at the bit to get it. Others are going to be reluctant. So I think this is where that Miosha risk analysis is going to loom very large. And you're going to absolutely pray that you had done it correctly and had done it thoroughly. Now, if indeed you are ever asked by a federal or state authority to be able to give them a list of your highest risk employees so that they can be prioritized, whatever the vaccination distribution method is. I don't think that that means, and I want to be very clear about this, do not make individualistic employees. You are not saying, you know, John, Tom, and Marcia are going to get it first because they're old or because they belong to a particular ethnic group that has been proven to suffer more from COVID-19. That actually would put you afoul of Title VII or the ADEA. You don't want to do that. You don't want to make an individualized list of prioritization. But I would make a list where if somebody comes to you and they ask you, who are the most important employees to be vaccinated? I would come up with the pecking order and say, classification by classification, this is what we think the priority should be. And if everybody's a low priority because maybe you work in an office environment and you understand there are people that need those vaccines more than you, fine, so be it. But I have thought about that ahead of time first. I think that that's a natural part. We need to at least have those conversations, even though it may feel scary to us as an employer to make those decisions. Step 4, if we are given a choice, once vaccines are rolled out by the federal or state government, decide how you will determine which vaccine you will elect to mandate and offer to employees. Oh boy. There are 3 available. Nobody knows how the government's going to divvy them. Nobody knows if there will ever be a time where you're given a choice. Are you going to allow the employee's preference to be the decision maker there? Okay, so be it. But is that going to have an impact on either your insurance costs or your work comp policy or, you know, any of your umbrella insurance policies? Is it going to matter based on cost differential to your workforce? How do you do it? I'm not saying you have to put a bet on one of those 3 horses. You have to say, we're going to do the AstraZeneca one. I'm not saying that. But I am saying that you need to know what the plan is going to be if the government comes to you and says, okay, you've given us your list of highest ranked priority folks. We're going to send vaccines out to you and nurses to administer them. Which one do you want, or which one do your employees request? You need to at least be prepared for the possibility that you're asked to participate in that process. Step 5, whatever policy goals we decide to implement, so whatever we decide for step 1, step 2, step 3, and step 4, we need to be able to have those documented and then communicate those policies effectively to the employees. I think everybody knows things are up in the air right now. All they want to know is that you're thinking about it, and they want to know why you made the decisions you did to the extent you made decisions. That's what they're going to want to know, and transparency, I do think, is going to be the best disinfectant to prevent there from being a lot of angry or frightened people from this process in your workforce. And then finally, step 6, this is crucial. Loop in your work comp carriers, your liability insurers, your legal counsel when you're making these decisions. This is brand new for everybody. Let's put our heads together and not go in alone, okay? Our penultimate section, although both this and the next are very brief, I've given you what I call Santa's little helpers. They're 5 quick tips based on the fact that I get these 5 questions more than anything other than the vaccination question or the remote work question. These are the ones that come up most commonly. So I want to address them specifically and individually. These are tips to solve common workforce management nightmares. Now, one of them Kim already alluded to, and Spectrum Health, as a partner with this presentation, has provided us with some very useful information, because the most common individual question is, where can I get tests? How am I going to get my employees tested? We need to know. Somebody thought they were in contact with somebody. What are we going to do? And first of all, don't scream at the computer screen. I understand the need. It is very urgent. You are completely right. But this resource, I think, will at least help you, because it is hard for employees to go and find tests. And just because somebody has come to you and said, I couldn't get an appointment for 5 or 6 days through, you know, whatever the hotline they preferred to call is, doesn't mean that your choices are exhausted. This slide is one of the most important slides in the entire presentation. So slide 82, for those of you just listening to it, go download the PowerPoint or the PDF or ask for it from me by email. Spectrum Health has a hotline that employers can call, where they will be able to at least walk you through the process of trying to find an entity that can come in to give either employee workforce-wide tests or that can make some available to you. That number is displayed there on your screen. The current turnover time turnaround time for inquiries that are placed there, it's about 48 to 72 hours. It's hardly ideal, but it's a darn sight better than a lot of entities are able to do. Spectrum Health deserves some applause for that. The other entities, Helix, NextGen, and Trident, also offer a variety of both on-site and in-lab testing services for your employment workforces. Their contact information is also available. and their turnaround times range from 24 to 48 hours. These are resources that you can call upon if you're having a great deal of difficulty making sure that your employees are tested. And I urge you to try them before you've given up in exhaustion or you've passed out from screaming and worrying so much about this topic. Question 2, what is the difference between isolation and quarantine, and how long does the CDC need you to do each? Emphasis on CDC. Now, the reason I think this is so tricky, and the reason that even though you've heard it a million times, it's having trouble sticking, is at least for me, I guess the colloquial, the common definition of quarantine and isolation are reversed from the actual technical terms the CDC uses. And that makes it impossible for me to remember, but they're the experts, so I guess my understanding of those words is just wrong. But here we go. Here's the answer. Again, another important slide you can just print out, slide 84. Isolation is where sick people are separated from well people. The isolating person is the person who is or believes that he or she is sick. Who? It's employees who have tested positive for COVID-19. They have it, they're a confirmed case. Or who have the principal symptoms of COVID-19. They're a suspected case. Those are the folks who need to put in the isolation protocol. How long before they can return to work? Well, if they've had symptoms, because of course we know many cases of COVID-19 are asymptomatic. If they have symptoms, 10 days after the symptoms first appear, their isolation can end. If the following 2 things are also true. They've gone 24 hours at the end of that 10-day period without a fever, without using a fever-reducing medication, so naturally not having a fever for 24 hours prior to the expiration of the 10-day period, and their other symptoms are improving, but there's a caveat. If you lose your sense of smell, if you lose your sense of taste, those can last for a long time. I had COVID about a month and a half ago. I was very blessed and fortunate that it was an extremely mild case, bordering on asymptomatic. I was actually very surprised that I got it. Although my sense of taste and smell returned after about 3 weeks, I do know some people for whom that symptom has lasted for months. The CDC has determined that just because you're having that symptom doesn't mean you need to stay isolating. It just is going to be a little bit of a down regulator on how pleasurable your life is. Certainly made Thanksgiving rough for a lot of people because they weren't able to enjoy it, which is a shame. If you don't have symptoms, there's a separate protocol that the CDC recommends, which is that 10 days need to have elapsed since you got your asymptomatic positive test. After those thresholds have been met, you can end your isolation. And beautiful, the Miosha regulations refer to the CDC, meaning that when you met the CDC standard, you've met the Miosha standard. And HB 6032, the one that says employees must not report to work, shall not report to work when they are ill, or they're going to have a cause of action against you if you demand it or retaliate against them for it. HB 6032 also defines the isolation period the same way. Great. Isolation's easy. The CDC, Miosha, and state law all agree. We're golden. Not so much with quarantine. Quarantine is, the purpose of quarantine is to separate and restrict the movement of people who were exposed to see if they become sick. So this is a situation where you have quote unquote close contact with somebody that either is suspected or is confirmed to have COVID-19. Who needs to quarantine? Unfortunately, this is a place where the CDC and the state law differ. The CDC says anybody needs to quarantine if they have been in quote unquote close contact, we'll talk about the definition of that in just a second, with someone who has COVID-19, excluding people who have had it within the past 3 months. In other words, the CDC only says you need to quarantine if you are a confirmed case. In other words, if the person they're exposed to, the person they had close contact with, is a confirmed case, then the person that came into close contact with them then needs to quarantine. HB 6032 does not agree and implies a more stringent standard. HB 3062 says employees who have been in close contact with somebody who has been diagnosed, so that part agrees, or who has been displaying the principal symptoms of COVID-19 needs to quarantine. Oh boy. Well, what do we do if the CDC guidelines and state law conflict? I think that the answer is we need to, at the bare minimum, follow what the state law says if it is the one that is stricter. And we have a decision about what we want to do if the CDC's recommendation is stricter. But overall, I think to make sure that you're good on both the Miosha side and the HB 6032 side, You use whichever standard between the two is more strict. And you say to your employees, this is the standard that we are going to have before you're able to come back to work out of quarantine. I don't think there's any other way through that mess. Now, again, the Miosha standard refers to the CDC. So as the CDC changes, Miosha implicitly incorporates that change by reaching in and pulling the CDC stuff forward. HB 6032 has it written directly into the law, so the only way that's going to change is if it gets amended. In other words, if the CDC radically changes their quarantine standard in a month, HB 3062 will not radically change. So we got to always be mindful of that. How long do people need to quarantine for if they meet the standards that are above? Again, there's some difference. The CDC says 14 days from contact. They are considering changing that to 10 days from contact or 7 days from contact if that person who has come in contact has had a positive test, but that has not yet happened. The current CDC recommendation is 14 days from contact, close contact with the, in the CDC's view, the confirmed case. HB 3062 offers a different option. HB 3062 says 14 days from contact or until, and this is crucial, the close contact, the person with whom contact has been made, receives a negative test. That doesn't mean the person, your employee, who came into close contact gets a negative test. It means the person they came into contact with has the negative test. In other words, employee A has close contact with somebody displaying the principal symptoms of COVID-19 on day one. How long do they need to quarantine for to comply with state law? They need to comply for 14 days. They need to quarantine after they've come into contact with a symptomatic but possibly positive person. Or if that possibly positive person gets a negative test, then that person can leave quarantine at that point. Why? Because they weren't, they didn't actually in truth come in contact with somebody, close contact with somebody that actually had it. Again, this is a place where I think the right thing to do as an employer is you go with the standard which is stricter. And in this particular case, the CDC says 14 days from contact, full stop. I think that's the answer for the short term to make sure that we're on the right side of both Miosha and 6032. Question 3. Okay, what does close contact mean? Well, close contact has a definition that is actually shifting a little bit, but we'll discuss what it means. This is how you remember it. Remember this. This is the close contact cheat code. 6/15/48. 6/15/48. It's not June 15th, 1948. It refers to the 3-part test to determine whether or not close contact has occurred between two people. A person has come into close contact, according to the CDC, has come into close contact with a confirmed or symptomatic person if they are within 6 feet of that confirmed or symptomatic person for a cumulative total of 15 minutes within the 48-hour period before the symptomatic person starts showing symptoms or receives their positive test. That may sound counterintuitive, but that's really the insidious thing about this disease, right? People are communicating it, they're giving it to other people, it's communicable during a period of time where you don't know if you have it. The period of time after infection but before symptoms is one of the most contagious periods of the disease. So again, if there is a confirmed or symptomatic person, person A is confirmed or symptomatic with COVID-19, person B has come into close contact with them, according to the CDC, if they have been within 6 feet of them for a cumulative total of 15 minutes over the 48-hour period before person A has shown symptoms or obtained a positive test. Confusing, but once you get it, it's easy to remember because you can remember the cheat code, 6/15/48. But it has to get hard, right? Of course it does. HB 3062 defines it a little bit differently. It defines it as within 6 feet of confirmed or symptomatic person for 15 minutes or longer over any 24-hour period. Theirs is 6/15/24. Again, I think that the stricter standard with the longer time frame, when there's conflict between the two, you're certainly not going to violate HB 6032 if you comply with the CDC reg, because the CDC reg is stricter here. I think that we follow the CDC's advice in this regard if we can. Question 4. A lot of employers have asked me whether or not they can forget all of this trying to figure out about the 61548. Why don't we just use electronic contact tracing? Can we? Electronic contact tracing is this app that you have on your phone. What it means is that your phone continuously and silently pings other phone. It broadcasts an anonymized code, and everyone else who also has the app, their phone does the same. This is all kept totally anonymous. You can't identify anybody's individual code and tie it to their person. But what the app does is it aggregates all the data together. And then when there's a match, a person that later says, hey, I was symptomatic and this was the time frame where I was, then it alerts all of the people. It looks back in the logs and it alerts all of the anonymous codes that pinged them at the same time. There are a couple examples of this. There's one administered by an Apple-Google partnership. They, by the way, have gone into a binding legal agreement where they've agreed that they're going to discard the data after it's collected so that we don't have to be as afraid that it's going to be used for advertising or profit purposes by a company. PwC has an app called Check-In. From, which is an app company, has an app called Social Safety. And the questions that I get asked are, can we do this? Can we use one of these apps? Is there, especially if you have a big workforce that works in an open area like a factory, can we use this to help us make the close contact inquiry easier? Here's the short answer. Under the ADA, it's very likely lawful. Why? Well, one, because we have the eased standard from the EEOC about medical inquiries, but two, because all the data is totally anonymized. And the employer never actually can look to see whether at any particular time an employee is testing positive. It's not like this is a thing that goes into your blood and figures out whether you have it and then broadcasts to everybody what your status is. Instead, it relies on the user to go back and say, oh, shoot, I got my test done on Wednesday. The app figures out when you were communicable and then figures out the people that you were exposed to during the communicability window. I've independently analyzed this issue. I've also read what other lawyers have to say about it, and I believe that this process is very likely to be lawful under the ADA. Federal law is not going to be a problem. State law may prohibit employees from using the app, however. I know in particular that California has various state laws that would prevent it from being a mandatory condition of employment to require your employees to use a tracking app. But this also isn't really a tracking app, but I think suffice it to say, depending on what state you're in, there may be a law that prohibits this. We need to do the careful checkup for multi-state employers, but please know in Michigan we don't have such a law. State data privacy laws may also prohibit this. I am not a data privacy expert, but if you're curious and you're interested, we can link you up with one where they can do that analysis. Again, my understanding from having talked to Michigan state data privacy experts is that there's no problem with using one of these with the workforce, but there may be in another state if you're a multi-state employer. What's the other downside? Well, employees might hate it. So we think about, and I think that it has been proven both epidemiologically and culturally, Singapore is a country that values cleanliness and also values orderliness to a high degree. But even there, less than 20% of the population utilized Trace Together, which was the one that the government approved as a contact tracing app mechanism. People just kind of are creeped out by the thought that their phones are already checking on where they are all the time. They're even more creeped out to know that their employer could be watching them, even though that's not really what's happening. So it may be a tough sell with employees, albeit a legal one. It also could pose an FLSA problem, because remember, the FLSA says basically we need to record all of the time where employees are working when they're working. Well, now we have an independent record of when an employee is at work because their location's being tracked. What if that doesn't agree with our time cards? That conflict could cause us liability. Finally, public employers in the audience today, beware. We have a big issue with public employers because there are a whole host of constitutional problems that could potentially be at play, because as a public employer, you are a governmental entity and you may be restricted by the Constitution. Does that mean you can't do it? No, but it does mean we really need to sit down and hash that out before we do if we're a public employer. Question 5. Do we need to pay our employees for the time they spend putting on or cleaning their PPE? their personal protective equipment? Well, I think that the short answer is lean toward yes, but in actuality, the situation is a little bit more nuanced. Remember that the FLSA requires you as an employer to compensate your employees for performance of all principal activities, right? That's obvious. They're doing the job you hired them for. You need to compensate them for that time in some way, whether it's by salary, whether it's hourly, or whether it's for a non-overtime exempt employee through overtime. However, principal activities also include, and the law is very clearly established about this, activities that are integral and indispensable as part of the principal activities. Well, what does that mean? Well, in 2014, the US Supreme Court heard this case where people were working in this battery factory. And I guess the thing about, I don't know anything about batteries at all, other than electric cars seem still inconvenient to me. But apparently when you manufacture batteries, there's a lot of really acidic, toxic chemical stuff inside those batteries. It can apparently, if it gets in your skin or stays or gets in your lungs, can be really, really deadly. So as a result, the people who were working in this battery assembly line needed to wear head-to-toe PPE, including respirators. It took a long time to get on and get off. But also, they needed to shower after work because if anything seeped through the PPE, those employees could become very sick. Well, the employer did the right thing. They had on-site showering facilities there, but they required their employees to shower before they went home. They didn't pay their employees for that time. The employees sued, and the Supreme Court says it's a necessary part of the job, so per se it is compensable. The Supreme Court, however, has also held in another case that these employees that were working at a poultry plant where they needed to use PPE to make sure that salmonella didn't get in their mouth, through the nose, or in their skin, they didn't need to be paid while they're waiting to put on protective gear. The reason the Supreme Court decided those two cases differently is they said it's one thing to wait to put on your stuff that you need to wear to do your job. It's another thing to put on the stuff that you need to wear to do your job. The latter is compensable, the former is not. State law obviously matters too, because each state also has wage payment and discrimination laws. I don't think Michigan has anything that would apply here that would be offensive. I certainly haven't read any case that would suggest so. I do believe, and this is a faint memory, I must admit, that Illinois does, however. So you need to think about things if you're multi-state. What's the best answer in the end, though? Well, it's going to vary based on the job, but generally, the higher the exposure risk, again, remember when you made the risk classification, the more likely the time spent putting on or cleaning PPE related to COVID-19 exposure reduction, the more likely that's going to be compensable. So lean toward yes, it is compensable time. And for employees that are really vulnerable to the disease, where they are absolutely going to be at enormously high risk to put on their stuff, their face mask, their shield, their gloves, their gown, that time very likely is going to be compensable. So if your payment practices do not allow for that possibility, we need to update them. Finally, and this is a one-slide section, thank you for being so patient today. We have the final section, which is the feast of forgiveness. Quick PPP forgiveness tips, because I know it's the time of the year where we have a lot of employers that are doing that. For HR folks, this may not be your wheelhouse, but I also know there are going to be a lot of attendees today or folks that will listen to this later that they wear a lot of different hats. And if that's you and you're the one who's going to be applying for PPP forgiveness, these are some common problems because our law office does a lot of PPP forgiveness advising assistance, just little tips and tricks to read the statute, read the regs, figure out what's there. Here are some things that I've learned through the time that have come up frequently. First, there isn't a forgiveness application deadline. A lot of people are freaking out about this, and the reason that they're freaking out about this is because the application, the forgiveness application, has this expiration date up in the top right-hand corner. It used to be an expiration date of late July, then they changed it to be an expiration date of late October, then it's late November. All that means is that they're going to reevaluate the form periodically. It doesn't mean that you must apply or you're going to lose the ability for forgiveness by that time. There is no forgiveness application deadline. Instead, you'll start making payments 10 months after the covered period ends. So that's kind of the ad hoc application deadline. Getting your stuff in earlier means less interest is going to accrue and deferral of payments is eventually going to end. So you're going to have to start paying on your loan. Might as well get it in sooner, but there's no hard and fresh deadline. Your lender may have different requirements, but that's what the law requires. Remember that if you're a smaller borrower, you can use the quote unquote EZ forgiveness application. And if you're a really small borrower and you had a loan under 50,000, you might be able to use the 3508S form, each of which are progressively much simpler than the full application. But the EZ form is more than just an income threshold. It's more than just a loan size threshold, I mean to say. There are also all of these kind of complicated eligibility requirements. Make sure you meet them. If, by the way, if you've terminated an employee, even if it was for cause and the FTE deduction won't apply, you're not eligible to use that form by the technical definition of it. So you need to use the full one. Check carefully. Remember that your payroll and non-payroll costs are both paid during and accrued during the covered period. Those are all eligible for forgiveness. The standard is paid during or accrued during. So in other words, if you had an electricity bill, say, for a month in the covered period that you paid after the covered period ended, you can count that as a forgiveness cost. Likewise, if you have a bill for the month prior to the covered period ended that you paid during the covered period ended, again, you can count that as a forgiveness cost. There's a little bit of overlap on both sides of the covered period window. The owner compensation rule is very arduous. You need to check it carefully because it can be a landmine for employers who are applying. It's going to artificially limit the payroll costs that are eligible for forgiveness associated with anybody that is an owner of the company. It's too complicated to get into the details. It's too individualized to do it here. But the point is, if you pay money to somebody who's an owner and you're going to be claiming that person's compensation as a payroll cost in your forgiveness form, you need to make sure that you're complying with all the deadlines. An owner, paradoxically, is able to forgive less of the total payroll cost amount than an ordinary employee would be. You can count mortgage interest, which is one of the non-payroll costs, for any secured real or personal property. So in other words, if you have, for example, an employer that maybe has a lot of automobiles or a lot of vehicles that you guys maintain, and they all have these secured loans, you can count the interest you pay on those secured loans as a forgiveness cost. It's not just real property mortgages. And then finally, that transportation utility non-payroll cost. None of us knew what it meant. We all hoped that it meant parking. It does not mean parking. It instead means state or local fees that are associated with transportation. That in itself is a little bit ambiguous, but it does mean, through guidance that was recently issued, the biggest source of that particular type of non-payroll cost probably is not going to be forgivable. So adjust accordingly. That's it, guys. That's literally all that I have for you, but these are, I think, vital and essential tips. And it's especially going to be useful to consider each of these issues as we're coming into the new year. Thank you all so much for your patience and time. It's always an honor to participate in the Spectrum Health Employer Education Series. Please, if you're interested in any of the future tips, take a look at them and sign up. I'm always thrilled to give presentations. And if you have any questions about anything that I've said today, do not hesitate to reach out. I'm happy to talk with you through those issues, or reach out if you want a copy of the slides, which I can provide there. I can individually send them to you as well. Thank you so much all for your time.
Thank you, everybody. For those of you who made it to the finish line, you'll understand we'll get a copy of the recording out to you. And we'll make sure that all the Q&A questions that were posted in the chat feature have a response to them as well. Thanks so much.